Hi, I wanted to take this opportunity to explain the discovery process. So, the discovery process is the stage in a lawsuit after the filing of a complaint where each side gets to ask the other side for information and evidence that they don't already have, as well as get information from third parties through things such as subpoenas. So, the discovery process includes discovery tools such as requests for admission, where you can ask the other side to admit certain facts, to admit that they're true. And if the other side denies that a fact is true and you go through the trial and have to prove that it's true, you can get what's called cost of proof sanctions, which lets you get your attorney's fees for having to prove it. So that's the first one, request for admission. Another one is request for production. Request for production can include things like asking the other side to produce documents, to include photos, to include videos, to produce emails to you to help support your case. Another type of discovery tool is subpoenas. Subpoenas is where you can issue a subpoena to a third party to produce information, and this can include the same things as requests for production of documents. The main difference here is that the party that you're issuing the subpoena to isn't a part of the lawsuit. So that's another tool, is the subpoena process. The fourth tool is a deposition. A deposition is where you get to ask someone questions under oath as if they're at trial. There will be a stenographer there taking down everything that's said, and the intention and purpose of this is to get real-time answers from the other party. Because what happens with written discovery is that in written discovery, the attorneys review all of the information provided before it's sent over to the other side. So there's like a filtering process that occurs that doesn't occur in a deposition. Depositions occur in real time. There's a question and then there's an answer. The attorney can object, but generally instructions not to answer are entirely inappropriate. So typically what will happen is you'll really get a sense of what the other person is like and really get to force them to give you information and evidence that they may be otherwise trying to hide. You also get a sense of their demeanor. You also get a sense of how well they might answer questions under oath and how they might do at trial. So depositions are an incredibly useful tool. Another tool that we can use is special interrogatories. Special interrogatories are specially prepared questions that we ask to the other side. These can include things such as identify all people who have evidence or information that. It can include information such as identify the total amount of damages that you contend you're seeking in this lawsuit. It can include information such as, please identify all people who were at this meeting or at this event that you're contending help support your case. So it's a very useful tool because what it does is it lets you get all of the background and additional information that can be used later, whether that's at a deposition or at trial. And the final kind of tool is called form interrogatories. Form interrogatories are a form that's been prepared by the Judicial Council of California. And all it is a specific list of questions, such as please state your original name, your legal name, any names you've used in the past. It can include information such as if you filed an answer in this case, give us all of the information and evidence and people who have information relating to the defenses you've asserted in this case. There's also Form Interrogatory 17.1, which is incredibly useful because what it lets you do is when combined with request for admission, Form Interrogatory 17.1 forces the other side to give you additional information such as people, facts, events, and documents that support the other side's denial of a request for information. So the intention of all of this information and the discovery process in general is to get the information that we need to help trap the other side, to help win your case. And ultimately, if it goes to trial, this is the information that we'll be using to help you in your case. I hope that helps. I hope that explains the discovery process. And if you have any questions, please reach out to my team. We're happy to help.